of communications. Reference number 8 of 2015. Godfrey Kazinduka and 2 others by the Secretary General of the East African Community coming after the hearing.
Good morning. Can we have the presentation, please?
Your Lordship, I'm called Anthony Kakumbe, representing the respondent. The 3 applicants are represented by Counsel Michael Gaia. And you are ready to proceed with your proceedings.
Thank you. The matter today is for delivery of judgment. The judgment of the court will be read by Justice Muhammad.
Thank you, my Lord. Introduction. The applicants, Godfrey Kazinduka, Anatoly Wavugiru Jose, and Edward Chishahayo, are former employees of the Financial Sector Development and Regionalization Project, the World Bank project at the East African Community Secretariat. The respondent is sued in a representative capacity as the Principal Executive Officer of the East African Community, the EAC. The applicants filed this reference on 28th May 2019 under Article 30 of the Treaty for the Establishment of the East African Community, the treaty. The applicants seek for judgment against the respondent and for orders that the respondent pay them $63,000 in unpaid salaries for the month of March, April, and May 2017. Specific damages, general damages for the embarrassment the respondent has caused them, cost of the claim, and any other order the court may be pleased and deemed just to make. Representation. The applicants were presented by Mr. Robert Lugat and Mr. Michael Gaia and the counsel, where the respondent was represented by Dr. Anthony Kafumbe, Counsel of the Community, and Florence Ochago, Senior Legal Officer. The applicant's case. The applicant's case is contained in the statement of reference filed in this court on 28th May 2019. The applicant's rejoinder to the respondent's response to the reference and the applicant's affidavits filed on 9th November 2021. The applicants were employed by the respondent in the Financial Sector Development and Regionalization Project, a World Bank Fund project. Godfrey Kazinduka and Anatoly Wavugiru Jose were employed on the 15th March 2011 and Edward Chishahayo on the 22nd April 2013. Godfrey Kazinduka was employed as a resource mobilization specialist, Anatoly Wavugiru Jose as procurement specialist, and Edward Chishahayo as financial statistics specialist. Project was to end on 30th September 2016. It is the applicant's case that a 3-year work plan was approved by the steering committee to support the request of the 3-year additional financing of the FSD RP Phase 1. The 3-year work plan, alongside with other supporting documents, were subsequently submitted by the EAC Secretariat to the World Bank for approval, and that indicated that all FSD RP staff who had included under the initial phase continue to work under the additional financing for the 3 years. And the World Bank approved the additional financing on 29 September 2016 and also granted a 2-month extension in order to allow the project a smooth transition and to wait for the signing of the financing agreement. The applicants contend that on 19th October 2016, the Deputy Secretary General for Planning and Infrastructure told them through email that the World Bank had decided not to renew their respective contracts upon expiry on 30th September 2016. The applicants formally wrote a memo to the Secretary General to inquire about the status of their contracts. But the Secretary General convened a meeting on 1st November 2016, which concluded that the applicants should continue their work under the same terms and await the outcome of the funding agreement. The Secretary General sent a formal reply to the applicants and instructed them to continue working under their respective dockets. The applicants state that since they were not given letters of termination and were not paid their salaries, they wrote a memo to the Secretary General giving him up to 30th April 2019 to pay them for the period they worked from March to the end of May 2017. On 29th March 2019, the Deputy Secretary General for Planning and Infrastructure responded by a letter signed on behalf of the Secretary General requiring the applicants to hand over to the Secretariat the furniture, car number plates, and IT equipment in their possession. That as prescribed under Article 71H and I of the treaty, the respondent is responsible for the general administration and financial management of the community and for the mobilization of funds from the partners and other sources for the implementation of projects of the community, but has failed to execute the responsibility. The applicants seek from this court following orders against the respondent. A. Respondent be ordered to pay the applicants a total of $3,000 of unpaid salaries from March to May 2017. B. General damages assessed in the sole discretion of the court. C. Specific damages of $196,000 each applicant. D. Cost of the claim, and any other order court may be pleased and deemed just to make. The respondent's case. The respondent's case is contained in the response to the statement of reference and in the affidavit in support of the response to the reference dated 24th July 2019. The respondent contends that this court is not closed with jurisdiction to entertain the reference since the parties to it had agreed on arbitration in the case of any dispute. The applicants were not employed by the respondent, but by the World Bank as consultants on time-bound project contracts. As such, they were not appointed as regular staff of the respondent, and that this information was contained in the contract they signed. That is the reason why the World Bank paid the applicants a consultant's fee of $7,000 per month, which is well outside the pay structure of the community. The respondent further contends that the respective contracts do not have clauses for renewal, and that any renewal was at the discretion of the World Bank, which paid the consultant depending on satisfactory performance and budget availability. The respondent further states that the reference does not disclose any cause of action, and as such, at the very least, this reference, if prohibited, ought to have been against the World Bank. In the circumstances, the respondent prays that the court dismisses with the cause all claims in the statement of reference against the respondent and makes such other orders as deemed necessary. Issues for termination. At the scheduling conference held on 8th November 2021, the following issues were framed for termination by the court. A. Whether the court has jurisdiction to entertain this matter. B. Whether the reference poses a cause of action against the respondent. C. Whether the reference is time-barred. And D. Whether the applicants are entitled to the remedies claimed in the reference. The parties decide written submission. Make all highlights thereof. Mention of issues. On issue number 1, it is the respondent's case that this court lacks jurisdiction to determine the reference on the grounds that the parties thereof agreed on arbitration which is binding upon them. He explains that when a dispute involves a contract with written arbitration clause, dispute is resolved through arbitration. On the other hand, the applicant submitted that this court has jurisdiction to determine the matter in accordance with Article 30 of the treaty, read together with the EAC staff rules and regulations. However, they aver that 3 out of the 4 issues framed for termination should have been raised as preliminary objections on points of law by giving notice as required by Rule 39 of the African Court of Justice Rules of Procedure 2019. The rules. We find it apt to first resolve the issue of the appropriate timing for raising preliminary objections. This court in Attorney General of the Republic of Kenya versus Independent Medical Legal Unit, appeal number 1 of 2011, stated that a preliminary objection is a point of law which has been pleaded or which arises in the course of pleadings and which, if argued as preliminary point, the applicants do not dispute that the 3 issues are preliminary objections. Their contest is the procedure of raising the preliminary objections and when to do so. Relevant to this point is what was stated in Venama Senge versus the Attorney General of the Republic of Burundi, reference number 9 of 2012, and adopted in Union Trade Center Limited against the Attorney General of Rwanda, reference number 10 of 2013, that a preliminary objection should be pleaded in a reference and all documentation in support thereof must be annexed to the reference. In Emmanuel Makisa, Jawasi, and 748 others, versus the Attorney General of the Republic of Kenya, reference number 2 of 2010, and in Emmanuel Makisha, Jawasi, and 748 others, versus the Attorney General of the Republic of Kenya, appeal number 4 of 2011, the court further asserted that a preliminary objection, even though not raised at the executive conference, the court has discretion to consider it if it deems it compelling, since it is trade law that a point of law can be raised at any stage of the proceedings. It is on record that the issue of jurisdiction was raised both in the response to the statement of reference, at the scheduling conference, and in the written submissions. The respondent therefore satisfied the procedural requirements of the rules. Premise of the foregoing, we find no reason to deviate from the long established precedent and will proceed to determine the first issue concerning the jurisdiction of this court and the point of law. It has been noted on several occasions by this court that without jurisdiction, it cannot proceed at all. The determination of doubts about jurisdiction must precede the determination of the merits. In Mary Ayuviza and another, as the Attorney General of the Republic of Kenya and another, application number 3 of 2020, this court concurred with the rationale on jurisdiction in honors of Motor Vessel Lilian versus Catex Oil Limited, that jurisdiction is everything. Without it, the court has no power to make another step. In the case of Eric Kabarisa versus the Attorney General of the Republic of Rwanda, EAC reference number 1 of 2017, this court clarified that to succeed on a claim of lack of jurisdiction in this court, a party must demonstrate the absence of any of the 3 types of jurisdictions: Ration personae, that's locus standi, Ration materiae, and Ration temporis. Simply stated, these 3 jurisdictional elements respectively translate into jurisdiction on account of the person concerned, the matter involved, and the time element. In the instant reference, the respondent raised 2 of the jurisdictional elements, that is, Ration materiae and Ration temporis. However, as the order of difference of issues by the parties at scheduling conference, the usual logical sequence of things dictate them to discuss whether the reference is time barred without first has to entertain and determine the reference. In the case of Arcon International Limited versus Standard Chartered Bank of Uganda and 2 others, appeal number 3 of 2013, the appellate division of this court adopted the definition of Ration materiae as the power of the court to entertain and decide on the subject matter of the complaint before it. In the present reference, the respondent argued that the reference's subject matter is of an arbitration nature and not one to be litigated. The respondent further stated that the rightful venue to consider this case is through arbitration, as indicated in the applicant's letters of appointment and not in this court. To lend support to his submission, the respondent annexed said letters of appointments. Part reads as follows. Any dispute arising from or in connection with this contract shall be amicably settled between you and the EAC. Where an amicable settlement of a dispute or conciliation procedure within a fixed deadline cannot be reached, the dispute will be referred to an arbitration panel of 3 arbitrators. One arbitrator will be appointed by you, one by the employer, and the third by both parties. The arbitration panel shall use the arbitration rules of the EAC Court of Justice. On the contrary, the applicants contended that it is contradictory and wrong for the respondent to invoke the arbitration clause when the same respondent has invalidated the same contracts from which the arbitration clause arises. That is, the respondent who had asked the applicants to remain in office and abide with the South African staff rules and regulations, and as a result, cannot rely on arbitration. We find the argument by the applicants to be misconceived. To entertain it would be shifting the question from whether the court has jurisdiction over this matter to whether the arbitration clause in the letters of appointments clearly in the premises. This is not a question for this court. The exercise to answer the question as to whether the arbitration clause is applied or not lies with the arbitral tribunal. Even if this question was to be answered by this court, it will not be hard to track the origin of the reference. The reference is, in the first place, a dispute arising from a contract. Therefore, the breach of the contract alleged by the applicants is pegged on the contract itself. It thus follows logically that contesting the validity of the arbitration clause on the ground that the contract is invalid is erroneous. We say so because we believe the existence of this reference survives on the assumption that there was a valid contract that gave the applicants the contractual rights that are said to have been breached. In a persuasive decision of the United States Supreme Court in the case of Henry Shane Inc. versus Acker and White Sales Inc. 2019, it was unanimously held that contracts that create threshold arbitrability questions on arbitrator. In this case, Justice Brett Kavanaugh stated that the court must respect the party's decision as embodied in the contract. Standing from the same citadel, Long Hoffman in Premium Naphtha Products Limited and others versus the Field Shipping Company Limited and others observed, open quote, it is therefore necessary to inquire into the purpose of the arbitration clause. As to this, I think there can be no doubt. The parties have entered into a relationship, an agreement, or what is alleged to be an agreement, or what appears on its face to be an agreement, which may give rise to disputes. They want those disputes decided by a tribunal which they have chosen. In my opinion, the construction of an arbitration clause should start from the assumption that the parties, as rational businessmen, have intended and any dispute arising out of the relationship into which they have entered or purported to enter to be decided by the same tribunal. The clause should be construed in accordance with this presumption, unless the language makes it clear that certain questions were intended to be excluded from the arbitrator's jurisdiction. As Longmore LG remarked at paragraph 17, if any businessman did want to exclude disputes about the validity of the contract, it would be easy to say so. Lord Hoffman's opinion is resoundingly persuasive. We are convinced that the language in the letters of offer of appointments do not explicitly or implicitly host the arbitration clause. Moreover, the arbitration clause is not ambiguous. As a result, we hold in answer to issue number 1, this court lacks jurisdiction as one material to deal with the reference. Having heard as we have, we deem it unnecessary to delve into other issues raised at the scheduling conference, as the finding on jurisdiction alone sufficiently and conclusively disposes of the reference. Regarding costs, Rule 127 of the rules of the court provides that costs in any proceedings shall follow the event unless the court shall, for good reasons, otherwise order. In exercise of our discretion, having determined the reference at the preliminary stage due to lack of jurisdiction, we find it critical to order that each party bears on the costs. Conclusion: for the reasons set above, the reference is no evidence of costs.
Thank you. We have come to the end of our proceedings today, but I need to also to inform you, Council of the Community and Council of the Year who are here, that one of our judges, Justice Ngie, Ngie, this is his last session with this court. So on behalf of the council who appear before this court, if you need to say anything, you're welcome. Dr. Kafumbe as counsel of the community and Mr. Rugeia as a representative of the advocates who have been appearing before this court. And Rugeia is, I'm told, you're a personal friend to Justice Ngie. So if, starting with Kafumbe, if you have anything to say.
Thank you, Your Lordships. Your Lordships, I suppose at a time like this, the right thing is to thank Justice Ngie for all the work he has done for the community. It has been a long journey, and we all appreciate that there's a lot of work in the court. It is true. In fact, one would even be tempted to say that until recently there was even a backlog. But we thank you very much that notwithstanding the challenges and the limitations even during the COVID period when almost everybody had closed down, you were around and you prevailed. And Your Lordships, I hope it will be possible to have some kind of formal ceremony where we can say more than what we can say in court. But certainly on behalf of my colleagues, and there are quite a number of them in the community, we are very grateful that you are able to serve the community that way. And we wish you all the best in your subsequent endeavors. I thank you, Your Lordship.
Thank you, Dr. Kafumbe. Councillor Rugeia.
Thank you, my Lord. To me, it is, I don't know how to start, but I should not feel sorry that he's leaving, but it is exciting because he has traveled with us in during very difficult times and during very good times when we were still with even before we joined the community, we were still with officers. In my case, with the Revenue Authority, Justice Ngie had the opportunity to guide us to work for the community. Then what followed, I joined the Secretariat in the Customs and Trade Directorate, where I was responsible for developing legal instruments at the EAC. And Justice Ngie was at that time the Minister of Justice, and he was one of the senior officials who guided us in shaping these instruments. We could have customs and trade officers doing their work, but when it comes to the shaping of a legal instrument, Justice Ngie was then one of the senior officers that we could depend on confidently. And through this process, we became friends. And okay, as life goes on, now I'm in private practice, and it so happened that Justice Ngie joined the community again as Justice of the Court, and I've appeared for him several times. And I'm very happy that I'm on record that he has made decisions in my cases where I've appeared, and you never know. You know, I hope that now in his next stage, I don't know, we still have another level of the appellate decisions. I don't know if the rules apply that he may come back again at that level, or when you just give or you go back home, I hope that you'll have another responsibility to serve. You are still energetic and young, and we still hope to work with you in your next endeavors. In this case, we only wish you the best of luck, yourself and your family, and all the colleagues in the partner state. Thank you very much. We have been very happy working with you, and we pray that the Lord guides you in your next stage. Thank you, my Lord.
Thank you so much. We will not say much, as Council to the Community has stated. We'll have an occasion to have a formal send-off or a farewell activity concerning the able Justice Odas Ngie, who has traveled with this court for the past 7 years, and hopefully on 28th of this month, which will not be even a court day for us, we have accomplished his 7-year tenure with the court. And according to the treaty, then he has to go back and get other engagements. And we, as a court, thank him also for what he has contributed, not only to the court, but also to the community at large. And I wish him the best in his future endeavor. Thank you. We have come to the end of these proceedings, and have a great day.
Nice.